Now, I was invited to provide some introduction on the unitary patent because the three speakers will rather initiate a discussion on the unitary patent package than explaining in great depth what it's all about. So if you allow me, in a few minutes I will enlighten you on the unitary patent to get us all on the same level of understanding. So, as we all know, the European patent is a bit old, and here is the very first one, 0000001, and it was a patent on a pump, on a heat pump. And it was a very nicely written claim, so in terms of disclosure, I think this would have been a fine example. So we know what the European patent is. The European patent, harmonized application procedure, but problems when it comes to infringement. You have fragmentation of jurisprudence. So the European patent with unitary effect tries to remedy that incoherent, fragmented landscape. It does so by putting forward a bunch of legislation, and for the legal scholars, they probably remember that it's brought about by 2 council regulations here, and then by 1 international agreement. So the council regulations establish the European patent with unitary effect, whereas the agreement establishes the Unified Patent Court. Now, the implications are the following. The European patent with unitary effect and the council regulations, they relate to the unitary patent, stricto sensu, and the agreement relates to both the unitary patent and the old-fashioned European patent, which you can tell from now already it's going to be a complex landscape because you have different rules applying to different topics. And if you take it one step further, which I try to do here, and I split up the regulation and the agreement, and you split it up per topic, you can see that it's even more complex because some interesting and relevant provisions are embedded in the regulation, whereas some other relevant provisions are embedded in the agreement. So having a different scope altogether, because these rules will apply to the unitary patent, whereas these rules will apply both to the unitary patent and the regular European patent. And I'm sure that at a later stage, one of our speakers will delve into the consequences of this complexity. Now, as to geographical scope, just as a reminder, the European patent, so the old-fashioned European patent, applied to 28 countries, the EU countries plus 10, making up for 38, whereas the unitary patent, in principle, and I'm saying in principle, would apply to the EU member states being 28. But it's a bit more complicated. And I've tried to explain how we end up with this figure of 26 by playing football. So imagine that this is the playing field. What you see is that there are 24 countries here on the field. So 24 countries. 4 problematic players. One player, got off the bus. Not on the field. Spain. Another player, Italy, was out of the bus, but then recently decided they might be willing to get back on the field. So, which might bring us back to 25. And then there's Poland. Poland was still taking an early bath, and they're still there. I mean, they undersigned the regulation, but not the agreement. So it's very unlikely that they will enter the football field at all. And then there's Croatia. They're sitting on the bench. which means that they said yes to the regulation and yes to the agreement, but it takes some time to get it all going. But they might be entering the field soon, which would bring the figure up to 26. Last country which causes some trouble is the UK, because the UK threatened to step out. But according to the latest information I have, they might change their mind. And even though the referendum was not very positive, apparently the UK Patent Office is kind of stretching their mind to stay in. Complicated. Okay. But I hope you understand a little bit from it. So this is then how the Unitary Patent Court is being designed, and I'm sure that one of the speakers will explain everything about the local and the regional divisions vis-à-vis the central divisions, the Court of First Instance, then the Court of Appeal, and then the Court of Justice, which plays a very special role in this, on the one hand, EU patent, and on the other hand, somehow internationally flavoured patent. Having said this, the papers. So this is a very special session. It's not a general session, it's not a plenary session, it's not a parallel session, it's a parallel invited session. I should turn to the organizers to really know what they meant, but we have decided it means a parallel discussion panel. So we're going to have 3 papers to inform the debate, and then after the 3 papers we would like to engage with the audience on those issues. So in the 3 papers can be split up into groups. First we will hear an economic perspective, and in the economic debate a lot of attention and a lot of discussion is revolving around the notion of cost. What will it cost to have this European patent with unitary effect? And we'll first have Bronwyn Hall, who did some very, very new research on cost, and then we will hear Bruno van Pottelsbergen, who tries to step into the debate we're having now on the top 4 regime. So this latest proposal to have the cost equaling top 4 countries. Then we will turn our lens and we will enter into the legal debate. And in the legal debate, a lot of concerns has been voiced on the topic of trust and governance. And we have Esther van Zimmeren with us to introduce us on the notion of trust and how it applies to the unitary patent package. So having said that, I'm very happy to invite our first speaker, Bronwyn, and she has 15 minutes.
The paper itself, the thing I want to talk about, is about what we learned from from accession to the EPO, or accession to the European Patent Convention, which means the ability to apply for a European Patent Office paper. But as I had a few words to say about the unitary patent and what we learned from the survey that the EPO did and the stakeholder meetings that the EPO did on this subject from patent users. Okay, about benefits and costs and take-up. And this slide summarizes the view of the users about benefits and costs. Benefits are clearly lower transactions costs if you want coverage in a lot of countries, because it's a one-shop thing and there's going to be litigation in one location in principle. They also mention things like the fees you have to pay when you validate at the NPO, but also the fees you have to pay when you want to transfer ownership, which is more and more common these days among entities. If you have a bunch of patents validated at different national offices, they used to be, they're EPO applications, they got validated at different national offices. Transferring ownership of those applications then becomes a costly activity compared to transferring the ownership once of a unitary patent, because there are fees for changing the registration, etc. They easier to use if you wanted to write a licensing agreement for certain regions, because you would have coverage over all of potentially all of Europe, obviously, with the proviso that the Spanish and the Poles haven't signed on. and financing purposes, which is something similar, which is using a security for financing, okay, which is, again, an activity which is being done more and more these days. One-stop shop for litigation, which leads to, in principle, more certainty, and hopefully lower cost because there'll be more competition among lawyers. Now you have European-wide competition. On the other hand, if you look at what they view as costs, they're also worried that the litigation cost will rise because it's the European level and everything is more expensive, as we all know. The loss of renewal flexibility. You pay renewal fees to every country after the patent's validated that you want to keep it valid in. Okay? Well, one of the things they do, of course, is designate a whole bunch of states, maybe pay to validate in a bunch of states, but in fact renew in UK, Germany, and France because that's enough. Okay? But here you have to pay renewal fees automatically for all of Europe, or almost all of Europe, and in principle might be more expensive. Invalidity risk. It's true that it's a one-stop shop and there's more certainty. It's also true that if you lose in all jurisdictions, and as now happens, sometimes a patent is upheld in the UK and invalidated in Germany, or vice versa, and you lose that flexibility. A final thing, which I think is relevant, and it's going to, when I show you the EPC results, you'll see why. Small local firms expressed, particularly, this was, as I recall, it was Swedish firms, meaning not firms from less developed countries, but firms from a highly developed country, which was not a country where it's sort of number 6 on the countries that are validated. Okay, when firms choose under the European Patent Convention to validate, they validate in UK, Germany, France. The next 3 are the Netherlands, Denmark, and then Sweden. Okay? Small local firms were concerned about the fact that this would essentially lead to threats from multinational firms who now found it easier to have patents in Sweden or in another, economy. It's a little hard to understand that, but it's, they're taking out a national patent. They feel a little bit threatened if you've lowered the cost, and you've really lowered it. For the marginal cost of having a patent in Sweden is now essentially 0. And it used to be something. And so they're worried that they're going to suddenly be threatened by multinational entry, not necessarily entry into the economic market, but entry into the litigation activity and things like that. Okay, they feel threatened. Now, here's what I want to say about cost. Cost clearly matters. Okay, this is the results of the survey that they did, asking what percent of your patents would you have registered as a unitary patent in the last 5 years if the fees, including renewal fees, were the same as Germany, France, and the UK, okay, which is the key, essentially gives you the European market. The answer is 62%, okay, a large number. Now suppose the renewal fees are set at the 6-country level, okay, not the 3-country level. Now you get 19% doing take-up. Okay, it's pretty clear that the break-even point is between 3 and 6 countries. I mean, it comes through very clear in the survey. The interesting thing is the EPO did hear this. Okay, obviously they were there. They are worried about covering their budget, and I won't go into the details of how resources are allocated between national offices and EPO, but that complicates the story. But they are worried about that. The current proposals which I've seen, which are the 7th of May this year, they've come back with a new set of proposals, have fees, renewal fees to the end around the level of 4-country validation. Okay, so that's where it stands now. And there's a lot of detail, but this isn't the presentation that I can go into. Okay, so they did hear that there was the fees really mattered, and it really was between the 3 and 6 country area. Now, what did we do? Well, what we're doing here is something somewhat simpler, okay? Because as Gertrude illustrated, the complexity of the decision facing a firm that wants to patent an invention in Europe is now very great. Because, first of all, they have to decide, do they want to apply at the EPO for an EPO patent that they can then validate in Spain and Poland, Or do they want to apply for a unitary patent and then go and, do they want coverage in Spain and Poland? They have to go worry about that. They also have the choice of going to national offices. They still have that choice. And it's cheaper if they only want one or two. In general cheaper. I mean, it's... And price-wise, it's very hard to calculate cost. And you can look at fees. But we didn't try to use numeric costs here in this paper because of the fact that the real cost is legal cost. And that cost, depending on the avenue you take and which language you're working in, that's going to vary enormously. And we just, it's beyond our capacity at the moment. So we're just looking at what happened when we joined. When 12 countries joined, 14 countries, joined a regional patent system, namely those 38 countries that you see up until 2000 were 24 countries. And we're looking at the change, or actually I guess they were 20 countries. So I'll skip this because you know what the European Patent Convention is. Accession to the European Patent Convention. Mistake there, EPO. The pre-2000, it's the usual suspects, which you can see there. The average GDP per person in those countries was $34 million. This was a presentation originally came from a U.S. presentation. Sorry about that, but you can convert. Our sample of firms that acceded to the European Patent Convention, we're going to ask what happened to patenting in those countries, is a sample of 14 firms, many of which are Eastern European, because that's, the group that joined during that period, 2000-2008. However, we do have Norway and Iceland, which have a relatively higher income, and we have Turkey, which is not a union member, as neither are Norway and Iceland. The average GDP of these countries is lower, and without Iceland and Norway, it's half what the GDP per person is in the original countries. And then there's another 4 countries that joined later for which we don't have enough data. And I'm sure you can imagine the patenting activity in San Marino. It must be really something. I suspect very little. So we do a little toy model in the paper that I won't bore you with because it doesn't add much. The idea here is what happens when you join the European Patent Convention. Residents in the country find it cheaper to obtain coverage in the rest of Europe. Non-residents that already are applying to the European Patent Office find it cheaper to get coverage in the accession country, right? Because now they can just add it. In fact, except for the translation problem, which exists, adding is quite cheap after 6 countries. You can designate for free after 6. And the full costs are difficult, as I say, to compute, and that's why we avoided it at the moment. So we predict that domestic entities are going to file fewer patents with national office and more with the European Patent Office. More domestic entities are going to obtain patent protection domestically just because it looks like a better deal, because of the fact that they can get Europe too. Fewer foreign entities apply for patent protection with the national office, and they validate an EPO patent instead. Okay, that's what you'd expect. Now you can just, on the margin, you can get this other country if you wanted it. More foreign entities do indeed obtain patent protection in the country, choose to exercise that option, meaning changes to the intensive and extensive margins. Now, what we look at in this paper at the moment, and also because of 15 minutes, which, it's a short time period, because we do have other things in the original paper, is the impact of the accession on the aggregate patent filings from that country, at the EPO, at the national office, by residents in the country, and by non-residents. The results are pretty striking, I think, and raise some questions. Even this sort of trivial aggregate look. We're looking at individual firm behavior and sector behavior. I'll just tell you right off the bat that, when we talk about patenting in these, particularly in Eastern European countries, we are talking about chemicals, okay? I mean, when you look at there's basically nothing but chemicals and pharma going on, which is by itself suggestive. But we're not doing it here. So the data comes from PatStat April 2014, and that's my excuse for giving this paper effectively twice at EPIB. I did 3 years ago. Hopefully none of you were there. We've updated it completely, and we've added 2 countries. We obtained from, besides PatStat, we obtained from Dietmar Harhoff, to whom we are very grateful, information on the designation and validation in the different EU countries, so that we know whether the patent was actually taken out in that country, as opposed to whether they designated that was a state that they might want to take it out. Only 44% are actually validated in the designated states. Now, only 44% of patents are validated in designated states, which is to say, firms designate a lot of states they might want to validate, which they don't validate. 5? Yeah, okay. I think we can get there. This is a table which we'll skip over, but this is the countries, and the interesting thing is they joined the Patent Convention before they joined the EU. Okay, maybe it's easier. Whatever. There's no budget test. Okay, so this is the basic fact, which is a bit, in some ways, mysterious. This is patent filings by residents of accession countries before and after accession to the European Patent Office. Okay. So what happens? Well, first of all, most of their filing is national. That's the top line. It drops very, 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 very slightly, right, after the red line. Teeny bit. The bottom line is the ones who file at EPO only. Oh, I should have said, these are based on priority, on equivalence, on patent families, right? So I have a patent family I apply at the EPO and the national office simultaneously on the same invention, right? So where's the mystery here? The mystery is the middle line, okay? At the red line, it becomes free to get a patent in my country by filing at the EPO and validating in my country. Nearly free, not completely free, okay? I do not change my behavior at all. So it's really a puzzle. These guys are applying for patents at the EPO. These are residents of the accession countries, and they're applying for national patents on the same invention, and they're not changing their behavior. Now, we can think of some reasons for that, okay? Like, we get different claims from the different offices, right? We like to FUD, right, for our competitors, fear, uncertainty, and doubt. You know, who knows? I might get one here and not get one there. The process takes longer here than it does there, and so forth and so on. So I can think of reasons, but it's interesting that you don't see it in the data. You do see a tiny increase in EPO filing at the very bottom by residents, but it's very small. So I think what this tells you is there is some reason why these small firms might be concerned. And that's in this slide, okay? This is what do the non-residents do? The non-residents look at the thing and say, oh, well, I don't need to apply here anymore, and I'm going to the EPO. And that's what they do. The little hump is actually quite odd. It's Norway, and I have no idea. It's coming from Norway, which is one of the big actors here. It wasn't there when we didn't have Norway. And it says, it takes them 4 quarters to figure it out. But, there's something behind that, but I don't know what it is, and I'm sure a real expert here might be able to tell me. So the resident behavior here, the red behavior, it's unchanged, and the blue behavior is the non-residents, and they say, we're going to the EPO, as you would expect. Okay, this makes sense. But just to remind you, validations in accession countries, the left-hand scale, the blue line on this graph, is scaled up to 200,000, okay? The red line is scaled up to 200. So, the residents are 1,000th of the non-residents as far as validating in accession countries total. Okay? So the residents are just, not in the picture. I had to do 2 scales because if I didn't do 2 scales, you wouldn't have seen the residents, in fact. They were all at the bottom. So that's kind of interesting. Now, we do a regression the reason we do the regression is purely because there's different time periods here and all, and we want to adjust for that in countries and blah, blah. But it says the same thing, so I won't spend time on it. I'll just summarize my predictions. Okay, domestic entities file fewer patents and more with EPO. There's a very weak increase in EPO filings observed. More domestic entities obtain patent protection domestically. There's no increase visible. Fewer foreign entities essentially cease filing at the national offices, and it says 20 times here. What happens with the foreign entities validating is there are about 20 times as many validations in the country as there were applications in the national offices before accession. Okay? In other words, if I was a firm from outside the accession country and I wanted to cover an invention in Hungary, say, okay, before accession I took out a national patent. After accession, I validated 20 times as many patents in that country. In other words, the lowering of the cost of getting coverage in Hungary caused me to cover a lot more in Hungary. And we have a new puzzle, which I already discussed, which is in some cases residents file both EPO and national patents for the same invention both before and after, which is unexpected accession. And so I'll stop there, but what it says to me is we probably ought to worry about the fact that we've complicated the system by introducing the unitary patent, okay? Because this tells you that a complicated system causes firms to try to use all pieces of it, okay, simultaneously.
What I present is some work that I've done first with Jérôme Dangui on simulations and a policy brief that will soon be ready for Bruegel on the fee and budgetary issues that Browin talked a little bit about, saying that it's complex, and I'll try to show that it's not very complex actually, it's very simple. It's simply financial flows and in and out, and you wonder whether the unitary patent will affect you or not. So this has been described. This is the current system. The unitary patent is not there yet. So the consequence of this, I will focus on fees, because there is a lot of issues, and the next presentation by Esther will talk about the Unified Patent Court. But the current system is this one. Broadly speaking, if you want to go to 6 countries, you are 4-5 times more expensive than a US patent for protections for about 10 years. If you go to 13 EPO countries, you are at 30,000. And this might be an important explanatory factor of the result of Brown-Winn. When accession countries enter the European Patent Convention, this is the picture they see. And of course, it's when you look at their GDP per capita, they have less resources to enter into that system, which is already complex. So the consequence, this is another picture, is the evolution of cost of the current system compared to the USPTO. And you see that the bad news is when the patent is granted. I have argued in previous papers that the left-hand side, the higher cost, justifies some higher quality. I know it's not politically correct, but European Patent Office generates a higher quality examination services. But when it's granted, this is when it becomes the bad news. And I've already said in my university, when we received a letter from the EPO that the patent is granted, if we don't have a market lead, it's a very bad news, because costs do affect our behavior. We are high-tech, we have high-tech patents, and either we license them to large companies or we create spin-offs. And I'll come back to that a little bit with respect to what Brown-Winn said. So the consequence of the current system: prohibitively expensive for wrong reasons. Nobody reads the translations. Renewal fees in national patent offices that didn't do anything to grant these patents, so it's pure profit, benefit. Uncertainty, parallel processes, and incongruities. You have plenty of cases. I don't want to enter into that. We've been publishing about that. So now I'd like to look and to talk about the budgetary issues, fees, because this is part of the debate and it's not public. It has never gone public, and it's the real debate. We are in pure policy making. It has financial consequences. It affects the behavior of countries. And it comes from the distribution of renewal fees. At the moment, renewal fees from European patents that are validated in these countries, and by the way, these countries love it, because in some countries the head of the patent office look at this manna from heaven. When you switch to 2,000 validation of EPO patent in your country, suddenly it's a beautiful budget. So if you take the Deutsches Patentamt, so half the new renewal fees go to the EPO, and the DPA have at least 100 million euro per year for doing nothing, because they don't examine these patents. You take UK and France, it's at least 45 million euro, and the same amount for the EPO. All these renewal fees corresponds to about 25% of the EPO budget. So for EPO, it's very important as well. They don't want to lose that money because you have to secure your business, the business of examining patents, for which they have a monopolistic power. And then National Patent Office is the same thing. You don't want to lose these resources because, well, they are much larger than your yearly budget, but you don't want to lose them. Okay. Just a remark, don't expect much, and I think that Brouwen's presentation confirms a little bit that from the unitary patent at the moment, it's a very important first step, but we still need political power to make it efficient in Europe. These are the UP4 proposal, and I was pretty happy to hear that it was UP4, so it's the blue curve. Sorry, we are really in the making of this paper. It's going to be released in the 2 to 3 weeks. So the blue curve is the new renewal fee proposed by I don't know who, some people at the EPO and national patent offices. And it corresponds to 4 countries. This is what we have been proposing for the past 7 years with my co-author. And why did we propose 4 countries? For a very simple reason. If you take the patents that are still valid today and that were granted 15 years ago, on average, they are active in 4 countries, which means that on average, the industry is ready to pay for 4 countries, on average, of protection. And we like it because it will reduce drastically the relative cost. So you see, the top curves are EPO, the current system for 13 countries, 6 countries, and you have EPO for which is much smaller, still higher than in other countries. So you have now the new proposal. You have a drastic reduction. This is absolute costs, and we go closer to the US Patent Office. But in relative cost, you divide that by GDP or by capita of the covered geographical area, then we become we reach nearly the same level as the US. And we become probably, we have to check, we are still working on this, and Japan, of course, has a much higher relative cost because of the size of the population or GDP. Okay, so now when you do the debate, the key issue is that when you open the system, the budgetary impact will depend on the percentages of unitary patent within the whole EPO granted patent. And the fear, and they are right, is that the first 10%, let's say the EPO grants 60,000 patents a year, if 6,000 of these patents go to the unitary patent, the fear is that these are the patents that used to be validated in all the countries, like pharmaceutical, chemistry, the biotech. And if you do that, you lose a lot of resources, both the EPO, because the renewal fees at a split will be drastically vanished, and the national patent offices. So what we hope, and everybody should hope, and it's a bit the paradox, when we open the unitary patent, we should pray that we have a large percentage of unitary patent. Otherwise, there will be a drop in resources. And we have simulated this non-linear effect, because, and for loss gain of renewal fees from the EPO viewpoint, you see that you have with 0% of unitary patent, it's 0% effect. But you see that they lose per patent something like €600 per patent if you have only 20% of unitary patent on average. And when you reach 40% of unitary, you start making resources. And then for national patent offices, it's the same thing, but the problem is how do you split the unitary patent cake renewal amongst the patent offices? And that's still under debate. So we took a GDP distribution fee. I know it won't be the same, but still it's interesting to look at it. And of course, the country that will lose the most is Germany, because at the moment it's the country where all patents stay the last time. It's the last country you keep a patent in force. Because, by the way, it's not because you have a patent only in Germany that you can't license it for the whole Europe, or even the world. Because the licensing negotiation can include other types of geographical coverage. But still, so Germany enjoys being the largest country within the European Union, which means it's the last country you keep a patent in force. It's not because Germany is particularly innovative, it's because it's the largest economic area, and by the way, also productive technologically. So quite a shock for Germany, and then France, a little shock, and so on. So we have looked, in our simulations that's going to be released, our proposal instead, because now that the renewal fees of UP4 are fixed, let's hope we keep this, national patent offices can play with their EP renewal fees, because it's their own decisions. So we simulated to what extent national patent offices should increase their EP renewal fees or the national renewal fees in order to stay break-even, and it's about 20% increase in Germany, 5% increase in the Netherlands. At the EPO, within when the patents that are renewed or maintained, you have a small increase that would secure not losing too much money, actually staying break-even with respect to the current situation. And I'll come back to that. Are we fixing the system? Affordability, certainly. Low quality, certainly not. As long as national patent offices can grant patent independently with the same legal validity in their own countries, we have a problem. They should stop granting patent. They can do search, examination, advice, but granting is a problem. Complexity, we don't solve it. Bronwyn just said it. Uncertainty, parallel litigation, we partly solve it. Lack of coherence, partly. No coordination at EU level, no comment about that. Well, you all know that we had the national patent systems, we have now the European patent, and what we are thinking of is this unitary patent. And the problem is that as long as national patent offices can grant patent independently, we actually don't have a unitary patent, because you can file your incremental innovations at the national patent offices. So we still need some political courage to go to I would say an effective patent system in Europe. I know that I am a dreamer, but we are also here to dream for 2 minutes. So a few suggestions. We should suppress 2 of the 3 layers, because otherwise it's incoherent. Like in the US, you don't have a patent for Los Angeles, for New York, for whatever, Minnesota. You have a patent for the US, 1 patent for China, and this is what we should look at. The governance of the system, well, maybe Esther will talk a little bit about it, but within the EPO, when you look at the board, of course, it's a very complex institution. Adapt EP fees instead of the rest. And if innovation is the real issue, don't ask too much to the current stakeholders, because they have different objectives in mind. And I just wanted to go back to the argument provided by Bronwyn about SMEs, where they don't use the patent, but many multinational comes, at least for academic spin-offs, our spin-offs. If we don't have protection for the rest of Europe, they will never attract venture capitalists. Never. So it's not only the fact that it's expensive to go abroad. You have multinational coming in your countries, but we need to allow them to have protection in Europe. And I'll stop here. Thank you very much.
I will focus on the Unified Patent Court, and especially on trust issues, because there's a lot of talking about trust and the fact that we will need to trust the judges. We need to trust the Unified Patent Court. What does that actually mean to trust or to build trust? So I have been exploring that concept a bit, and it's actually quite a mystical concept. A lot of people use it in many different concepts. Also, if you're collaborating with another company, there needs to be trust between the partners. But what is that? So it's a very powerful concept, and it's used in situations of uncertainty when it would actually be surprising that people are still collaborating despite all the uncertainty that exists. And it still does exist. So if we, for instance, look at this statement from the second progress report of the preparatory committee, stating that they want to create a fully operational unified patent court as soon as possible, paying due attention to its quality and efficiency, as this will be necessary to gain trust and confidence. Also, trust and confidence, is that the same or not? There are actually quite some thoughts about that. Another document of the Council of the EU also refers to the training of the judges as a key determinant for users' trust in the court. So I was asking myself, what actually is trust? And is it possible to trust an organization, or do you rather trust people? And is the Unified Patent Court, as it is framed today, is it trustworthy? There are quite some theories about how you can assess whether somebody is trustworthy. So I'm trying to work with those concepts and applying that to the Unified Patent Court. And also exploring a bit how the Unified Patent Court could gain trust or build trust. So this is kind of an exploratory work that I'm doing, so it's still in an early phase. So if you would have any thoughts or questions, they're very welcome. When I was starting to read about trust, I discovered that there is quite some literature already on it from different disciplines. But a definition that is often used is this one from 1998, referring to a kind of psychological state where people accept a kind of vulnerability based upon positive expectations of the intentions or behavior of the other. So especially this concept of vulnerability, uncertainty, and at the same time, positive expectations about how something is going to work. So uncertainty is a key concept when you think about trust. And of course, as I said before, there's still a lot of uncertainty about how the UPC is going to function. We now have a consultation document with regard to the fees. We know that the judges are being trained, but we don't know who the judges are and what their background is. We don't know who the president will be of the court, which and the president will be very influential because we'll be taking quite some important decisions. Trust is also a relational concept. A trusts B with respect to C. So citizens and the users of the patent system will need to trust the Unified Patent Court in terms of an effective operation for the future. Trust is also dynamic. It's something that increases but can also very well decrease over time. So it's something that you need to maintain also over time. Trust and distrust, they're related concepts, but they work in different ways. They are selective, and it's important to think about the concept of trustworthiness and how does somebody or an organization become trustworthy. And it's also not necessarily the more trust there is, the better it is. It's more complicated than that, because trust needs also to be warranted. And so it is not that easy to set it up. And so there's also an interesting paper from Mullering, or at least several papers actually, thinking about trustworthiness. And so reasons or arguments why somebody would be trustworthy, so rational arguments. Why, so for instance, like the nice cost-benefit overview that Bronwyn gave earlier. So those would be reasons, either positive or negative with respect to the trust. Then routines. When the UPC is starting to work, it will build up different routines, particular doctrine, particular procedures, and on the basis of the effectiveness and efficiency of those procedures, that could either increase or decrease the trust. Reflexivity, that relates to experimenting of the Unified Patent Court and users getting experience over time, either positive or negative, and that will affect the trust base. But according to Mullering, this is not enough. Despite those reasons, routine and reflexivity, which are decisive for trustworthiness, there will still always be uncertainty. And so trust inevitably involves a leap of faith. So there should be a kind of suspension of this uncertainty, of this vulnerability. This sounds a bit abstract, but so the idea is that you act as if there is no uncertainty, as if you as a user of the patent system are not vulnerable to the system because you don't know what it's going to do. So there's that leap of faith which is central for trust. I think you can read also the gray. It's better on the screen, actually. But so there are different types of trust. The interpersonal or personal trust, interorganizational trust. So interpersonal trust, that's kind of logical. It's between people. It's the face work that does it, the actual interaction between people. And there the competences of a person, integrity and benevolence are decisive for trust. But these same elements also play a role for building interorganizational trust. So again, also their vulnerability is key together with uncertainty. And the organizational behavior or the norms of an organization, particular procedures of that organization, will contribute or actually decrease the level of trust. I'm going to skip over these because of time limitations. But so there's a lot of literature on different types of trust, different ways to generate trust. And I just hope that you trust me, that I give you a kind of reliable overview in the 15 minutes that I have. But there's also a relationship between this personal trust and organizational trust. Because actually, if there is a relationship between two representatives of organizations, so let's say, so we're in the UK, imagine a prominent UK judge, I think you could all imagine of somebody, with a lot of expertise, a lot of experience, and a prominent UK company with the patent attorney of that company. So they know each other, they have seen each other in court, they've seen each other at conferences, and there's a mutual kind of respect for each other's reputation, even though, of course, you know, they're not on the same side, but still they know each other, they know what their values are, and they might even have the same values. So if that person, if that prominent UK judge would become the president of the Unified Patent Court, that would reflect for that particular patent attorney positively on the Unified Patent Court. So that would, that interpersonal relationship would also have a positive effect on the trust that the patent attorney has in the Unified Patent Court. On the other hand, imagine that over time, this president will be replaced by another president, which is known by nobody. But in the meantime, the Unified Patent Court has gained some trust as an organization. So then the representative, the new president, will be able to benefit from the trust that has been built up in the organization, the Unified Patent Court. So there's a sort of loop between the two, which I find kind of interesting as a concept, and to apply it to the Unified Patent Court. So in terms of trustworthiness, there's also some more detailed theory around that, which I think is really helpful to explore the idea of trust in the Unified Patent Court. So there's a macro, meso, and a micro perspective. And at the macro level, it's all kinds of formal and informal institutions, rules, procedures and how they actually work, which will influence trustworthiness. On the other hand, also some calculative considerations, so more rational activities, like, again, for instance, this nice cost-benefit analysis from Bronwyn. I'm very happy she did that, so I can refer to that and I don't have to do it myself. Also, positive third-party information. So imagine, there's one company who's waiting a bit. They don't want to start experimenting with using the Unified Patent Court, with using the Unitary patent. So they wait for others to get this experience, and they will learn. They will get information from them, either positive or negative. And there are also relational considerations. For instance, the values within that organization, certain interpersonal appreciations. And then at the micro level, it would be this representative. So again, this UK prominent judge who would become potentially president of the UPC, the predispositions, the characteristics, the education, the reputation, the way that person has been dealing, that would all also be taken into consideration in that model. So with boundary spanner, that's the term that they use, it effectively relates to this representative of the organization. So looking at the UPC, I will jump this as well. What I just want to emphasize with this slide is that it's not only about trust between the users of the patent system and the UPC, citizens and the UPC, but also inter-organizational trust between the UPC and the EPO, UPC and the quasi-judicial boards of appeal, UPC and national judges, because there needs to be trust between these organizations as well. Otherwise, there won't be a dialogue, there won't be a kind of formal or informal collaboration. If the UPC doesn't trust the Court of Justice, they will not be asking many preliminary questions with respect to the interpretation of EU law. If the different divisions do not trust each other, they will unlikely be referring a lot to each other's decisions, even though they may be formally obliged to do so. But they may try to get around that. So there's also an element of inter-organizational trust there. So this would be the image, but I think it's already clear from what I just explained. So the conceptual framework related to trustworthiness, if I apply that, so the macro, meso, and micro level to the UPC, the formal and informal institutions, so the fact that the court is specialized, for some people that would increase trust, for others that would actually not be a very positive thing, because it has all kinds of negative implications as well, such as the risk of a pro-patent bias, which is also mentioned often with respect to the US Federal Circuit. The multinational panels and the pool of judges, the judges that will be rotating in order also to ascertain the level of expertise. So that could actually also increase the trustworthiness. The mix of technical and legal judges, also the fact that there is a very intensive training program foreseen both for legal and technical judges. So is there also trust in the Budapest Training Center, or is there trust in SAIPI, who will also do part of the training? Hopefully there is, otherwise we will need to talk with Xavier, who is also sitting here. The appointment of the staff as well is part of this whole trust mechanism. The legal framework, still uncertainty about the rules of procedure. We now have the 18th draft. There are not really major changes, but there's still some controversy about a number of issues. The financial regulations, the fees, there's a consultation document, but still outstanding. The decision is still outstanding. Then the electronic case management and filing system. It sounds really practical, but it will very much influence how the system is working and how effective it is. Then also the registry. Nobody's really talking about the registry, but they will play an important role in terms of organizing the opt-out process. So how that will be done will also affect the trustworthiness. Then, in terms of these calculative considerations, the cost-benefit analysis, in terms of the opt-out, how many people will actually start using that opt-out mechanism, again, will affect the trust in the system. These third-party information experience with use of the UPC, relational considerations. So the fact that this UK patent attorney is part of the patent community, just like this prominent UK patent judge, there's a kind of interpersonal appreciation that will be taken into consideration. Also values such as judicial independence, effectiveness, efficiency will affect trust as well. Then at the micro level, again, I already mentioned the education. Do the judges, do they have an LLM in IP law? Which languages do they speak? How did they effectively act in the whole training process? What is their career path? Are they career judges, or do they have some experience in practice as well? What was their term at the bench? Did they work at a patent office as well? How fair or just is the whole decision-making process? So that brings me to the end of my presentation. And I know there's a lot of noise, but I hope that I've been trying to convince you that so we will need a leap of faith by both the citizens and the users of the patent system because of this uncertainty. And it remains to be seen which companies, which users will actually be able to make that leap now or later on. So how many cases will we effectively have? It's a kind of leap in the dark for some. And the UPC will also need to remember that even if they will manage to build the trust over time, it only takes a few seconds to destroy it. So it's something that you need to continue building, and you can never stop paying attention to it. So thank you for paying attention to me.